Well, today I'm finally going to do it. I'm going to take a look at the YNW Melly Trial and give you my thoughts on that. Um, this has been an interesting case. We'll have to talk a little bit more about some of the things that are going on. Before I get started too far along here, I want to point out that particularly on a high profile case like this, I like to wait toward the end of the case before I start making commentary. I don't want to see anything that I do give an advantage to one side or another. Not that I think they'd be thinking to look on the internet for inspiration or guidance, but it also, I don't want to look ghoulish, like I'm a vulture kind of circling over this trial, trying to pick the flesh off the bones of the trial that is happening. So I'm always a little reticent, and particularly here where you have a double murder and you have rappers, which is a lifestyle that, I'll be frank, I absolutely know nothing about. And I don't listen to that music, so I'm not particularly interested in that culture. So with that understanding, let's move on to my commentary on this case. So one of the things that we often say as plaintiff's attorneys is that we don't get the luxury of having the perfect plaintiff. We never seem to be able to get the plaintiff who was the NFL place kicker, who got his leg chopped off by a doctor after he went in to have a mole removed. We never get that kind of case. So when you're a plaintiff's attorney, you take who comes through the door and you do your best to make them a good candidate for relief from the jury. And one of the things that we always talk about as attorneys is that we want a huggable client. We want someone who is sympathetic. We're not asking for sympathy, but we don't want somebody who's bitter and disillusioned and never smiles. We want someone who is relatable, someone who can make their issues known to a jury. And that's just good communication, and certainly something that I think most lawyers want when they interview a client. And I think the same thing applies on the defense side. I think the same thing applies because they want their client to be relatable. My favorite stories about a case that we tried in Columbia, Missouri. One of the doctors was a pulmonologist and the other one was a surgeon. And the pulmonologist came in and we asked him how long it would take him to get to the hospital from his house. And he said, "Oh, I don't know. It depends on how long it takes me to fluff up my hair, I guess." And he actually did that little thing with his hand. The surgeon, on the other hand, when we asked the first or second question about the client, he said, Oh, I loved Judy. She was such a wonderful person. I was horrified by what happened to her. And we made the decision at the end of our case to dismiss the surgeon and go against the pulmonologist, not because we didn't think we had a good case against the surgeon, we did, but because somebody had taken him to charm school and he was way better than relatable. He did not come off like a certified member of the AMA. He came off like your best buddy who just also happens to be a doctor. And so that's the kind of people that you want when you are prosecuting a case in civil court. Unfortunately, in the domain of criminal law, you don't get that kind of selection. You don't have the option of saying, well, I think I'll pass on this one. This double murder is not really that bad. No, you have to take what you're given and go with it. So for those of you who don't know anything about this case, there is a rapper by the name of YNW Melly, whose actual given name was Jamel Demons. Now, he has a co-conspirator by the name of Bolton Henry. And he and Bolton got into a Jeep with two other people, and only he and Bolton got out of the Jeep alive. Bolton had gunshot residue on his hands, and and apparently was the driver, whereas YNW Melly was seated in the back, and the crime scene person said there was only one shooter, and that the shooting, that the bullets seemed to have come from the back end. That was the crime scene reconstructionist's testimony in this case. So almost at the get-go, you have a lot of problems in this case with respect to conflicting testimony. And perhaps the worst of this was one of the witnesses who, and I love it when the media has to put this kind of descriptor on someone. She was the mother of the ex-girlfriend of YNW Melly. Melly apparently called the ex-girlfriend, told her that he had been in a shooting, or in a drive-by shooting, and that the girl then screamed, and the mom came over and listened to a number of incriminating statements that Melly apparently made during the course of the phone call. So she goes and she talks to the cops and she tells them all these incriminating statements. And then a funny thing happens on the way to the courthouse. And by the way, it took 4 years to get this case to trial. So, it's been 5 years now since the actual shooting. So it really is there could be some room for, perhaps forgetting certain details. But here's what makes this interesting. After giving the police this statement, she then gets $5,000 from the manager of YNW Melly. And then at a deposition right before trial, it's like, I can't remember anything about that. I don't remember any of those statements. And so that has created a real problem for the prosecution. And then just the quality of the state's witnesses, they would like, I'm sure, to have put up Bolton Henry. I'm sure they would like to have flipped him against Melly and used him to sort of leverage him into a death penalty case. But that's not what happened, and at least as of today, that's not what happened. And instead, Bolton Henry has stayed far away from this courtroom. But they did get other people who were in the sort of inner circle to come and testify. But anytime you do that, anytime you use people who are in the inner circle of the defendant, you have to realize that they are subject to a great deal of pressure, particularly peer pressure and organizational pressure, plus you're threatening their income stream, among other things, if they're people who work for this particular rapper. And as a result, you wind up with this kind of testimony at trial.
So I'm going to talk about some prior stuff before we get into why you're here today. Have you previously been convicted of a felony? Yes or no?
Yeah.
And how many times?
To my best of knowledge, once.
Okay. If I were to show you something, would that refresh your recollection?
Yeah.
A prior judgment? Can I have permission to approach the witness?
Show counsel first, please.
Yes. I'm going to ask you to just look at the document, don't say anything. Okay? Again, an opportunity to review the document. You have to answer.
Yes.
Right? Is your memory fresh as to how many convictions you have?
2. What was that one? The other one? I'm not sure. Let's see, 2 charges.
All right. Now, you currently have some pending charges in Indian River County, correct?
Yeah.
And those are 2 charges.
Yeah.
Misdemeanor resisting without violence.
Yeah.
And an obstruction of service or execution of a search warrant.
Yeah.
Are those misdemeanors or felonies?
I'm not sure.
Okay. Do you know what the penalty you're facing on those charges?
No.
Okay. Have you been offered probation in that case?
Yeah.
And have you been made any promises in exchange for your testimony here today?
No.
Now, this is an attempt by the prosecutor to take the sting out of the fact that he has other charges, he has other convictions, and here he is testifying against his friend. But it will ultimately backfire, as you will see here in just a moment.
So, back on October 26, 2018, do you recall being at the New Era studio?
Yeah.
Who were you there with?
You other people.
This will be a frequent strategy of this witness during his testimony. He will deliberately give a very vague answer, and he does that, I believe, to frustrate the state. And he also, I think, is playing into the defense's objections.
To the best of my knowledge, people was sleeping, so we ended up going home because, sleep in the studio.
All right. And part of that is because studio time is obviously,
Paid for.
it's costly, right?
Objection to leave.
Stay.
Okay, you just said it was paid for. What was paid for?
Studio time.
That's a dumb objection. It's the kind of objection that really ticks off a jury, because all they want to know is what happened. And you've got somebody over here going, objection, objection. And then she just rephrases the question and gets the information in anyway. He would be better off letting a few of these go, I think.
Is someone upset that people were sleeping?
I guess you could say that, yeah.
And who was that person?
Sad.
Okay. And how did Zach respond? How did Zach respond to people sleeping?
Woke him up and let him know it's time to go.
All right. And how did he do that?
Yeah, he went and woke him up, shook him up.
All right. Was there an occasion where he threw water on some people to wake them up?
Objection, Your Honor.
Stay.
Your Honor, this is deliberate. Can we go sidebar, please?
Counsel, if you make an objection, make an objection. Don't be arguing in front of the jury. I told you that before,
I
all right?
understand. Can we go sidebar?
No speaking objections.
Can
Come
we go
sidebar, sure?
Thank you.
In this trial, the state and the defense have just not gotten along. And it's not the rhetoric, right? It's not, they're saying something that hurts my case. It's that I think to a large extent they just really don't like one another. And essentially, she's following up here on his explanation that they were woken up. And she knows that water was thrown on one of these witnesses. And she's trying to get him to say that, but because he's being very vague about how they were woken up, she asks this question, but she does it in a leading manner. And so now she's drawn this objection, and our defense attorney jumps up and starts objecting, and instead of just saying objection or objection leading, he starts arguing, and the judge has to shut him down. Before this trial is over, I am pretty sure the judge will be very ticked off at both of these groups of lawyers, because the state has got kind of a rotten deal in terms of their case, and the defendant has gotten a rotten deal because he is a rapper, and he is probably going to be presumed to be guilty anyway, because that seems to be one of the things that is associated, rightly or wrongly, with that rap lifestyle. So this again is an example of bad lawyering on both parts, and it ultimately is going to have the worst effect, I think, on the state.
There is a second individual at the red Mitsubishi vehicle. Do you recognize that second individual?
Not really, no.
Now, these are people that he's worked with for months. He's seen them. He just spent that night with them in this recording studio. And even though the video surveillance isn't exactly great, he's saying, "Oh, I don't know who those people are." This is the kind of thing you get when people are testifying reluctantly. And that's going to be a big clue to the defense here in terms of why this guy is testifying and what they might be able to get out of him on cross. The state goes through all of that material, and gets all this video evidence in, and then it's the defense's turn to cross-examine. And oddly enough, the witness doesn't treat the defense a whole lot better than it treated the state in this case. But we find out why, too.
So you smoke a lot of marijuana, right?
Possibly.
Well, you smoke it anytime you get a chance, I think is how you phrase it.
It's your answer. Yeah.
That was your answer.
I smoke when I smoke.
You smoke when you smoke?
Yeah.
And when's that?
When I smoke.
And when would that be?
When I smoke.
How many times a day?
Objection to asked and answered.
Overruled.
Twice, 3 times, maybe.
Okay. And
The defense attorney here is trying to point out, as most people know, that smoking marijuana chronically will reduce your ability to recall things. It tends to slow you down a little bit. And he is sort of testifying like a chronic dope smoker. And as a result of that, he doesn't really want to answer how often he smokes or what he smokes or any of that. And he kind of fights with the attorney on that. But as I said, we're going to find out why in just a moment.
and you are now out on pretrial release.
I bonded out, sir.
Okay. And while you are on bond, you are of the opinion that if you don't come here,
I'll be in jail.
Objection, Your Honor, closing.
That's the only reason I have.
Excuse me. What happens is when they make an objection, just wait before you answer. Objection, no, it's overruled. Proceed.
That's
you're of the impression that if you don't come here and sit in that chair and testify, you're going to go to jail.
correct.
Throughout this trial, there have been numerous objections and numerous sidebars and numerous times that the jury has to be sent out. Now, when it's a minor issue, something that they can handle at the bench without anybody getting loud and out of hand, they usually try to do that, and they usually try to keep the jury seated. But a lot of times the issues are so significant, or the objection is so significant, that they need to send the jury out so that they can have a conference and each attorney can make their case in a way that they would make it if there was no one in the courtroom. As a result of that, this trial has taken about 3 times longer than it needs to have taken. A lot of the objections have been somewhat frivolous, and even the ones that haven't been frivolous sometimes have been unnecessary because there was other ways to get the information in. Now, tomorrow we're going to take a look at the testimony of the last witness for the state in this case, who is the detective, and I'll have some suggestions about that tomorrow. So that's as far as I'm going to go with Melly today. I am going to say that if you judge anything by the comments on the live stream or the comments on the what I would call the news commentary that you'll find on YouTube about this trial, it looks like Melly is doing pretty well and his lawyers are doing pretty well. There is a lot of evidence that could point toward reasonable doubt. Whether that will bear on this jury or not is hard to tell. And of course, at this point, the defense has not had an opportunity to bring in any of its witnesses and tell any part of its side of the story. And of course, it doesn't have to. It could stop tomorrow and say, hey, they never made their case. We're not going to bring a single witness. You don't have enough to convict this guy on the basis of this evidence. And sometimes that's the absolute best approach to take. We'll just have to see how this all shakes out. So join me back here tomorrow. We'll take another look at this case. Before you go, I want to remind you that kindness heals wounds that the human eye can't see. There are a lot of people out there carrying burdens that you have no knowledge about. It might be something small. It might be something soul-crushing. Anytime you can do something nice for someone, particularly if you see that someone's in a hurry, let them go in front of you in line. You may very well be making the difference between a good day and a bad day for them. Please try and do that. Let's all try together to make the world a better place. And then maybe people like me, lawyers, us salty old curmudgeons who settle problems for people, Maybe we wouldn't be so necessary then. Thank you so much for watching. Come join me down at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.